Hi, everyone. Thank you for joining today's webinar presentation. I'm Gail Martin, Associate Marketing Manager at LexisNexis IP, and I want to cover a couple things before we get started. Please feel free to submit questions during the conference by using the Q&A feature, and you can download a copy of the slides from today's presentation through the panel. These and a link to the recording from today's presentation will also be sent to you. Now, I'd like to introduce today's presenters. Gene Quinn. Gene is the founder of IPWatchdog.com, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Gene was recently named one of the world's leading IP strategists by IAM for the second consecutive year. Joining with Gene are two patent attorneys who practice at Kilpatrick-Townsend, Kate Gaudry. Kate focuses on data-driven and strategic patent prosecution. She routinely performs empirical analyses of general, portfolio-level, or application-level prosecution techniques to inform her client strategies. Kate holds a JD from Harvard Law and a PhD in computational neurobiology from UCSD. Joining Kate is Samuel Hayim. Samuel focuses his practice on patent counseling and prosecution in the software and electronic arts, in particular, software development frameworks, control systems, and telecommunications. Prior to joining the firm, Sam was patent examiner at the U.S. Patent and Trademark Office for more than 7 years. Thank you again, everyone, for attending today's presentation. And with that, I will turn it over to you, Gene.
Thanks a lot, Gail, and thank you all for spending a portion of your Thursday afternoon with us here today. We have a good conversation in store for you, and one that when Kate came to me and said, "Are you interested in talking about this?" my eyes opened wide because I almost couldn't really believe what she was telling me. So what I'd like to do is let's jump right into it, because I think we do have a lot to cover. And given how many folks have been registrants here, I suspect we're going to have an awful lot of questions. So please feel free to shoot us your questions at any point in time during the webinar. I'll try and weave as many in as I can during the webinar, and we'll save some time at the end to get to as many of them as we can. So if you are watching this on the computer on your GoToWebinar control panel, there will be a tab that says questions, so you can just enter them there and I will see them. So let's go to the outline here, and this just very briefly talks about the three things that we want to try and cover here today. And Kate, I'll ask you first, and Sam, I'll ask you the same question. What is it that you want people to know about or understand with this area of artificial intelligence and what's going on at the Patent Office before we really start to break it down and get into the nuance? Kate.
In terms of the general data trend?
Yeah, or just, prime the well, if you will. What is it that you want folks to have in mind as we start the conversation?
Okay, so I imagine that most people on this call already know that there has been a big transition in terms of how many software applications have been examined at the Patent Office, and generally it's gotten harder to get software patents. That was particularly true for business method patent applications, and artificial intelligence was rather immune to those challenges for a long time, but our results are showing that that's changing dramatically. And so artificial intelligence is being roped in, and it's now, what we're finding, there's a recent trend that it's getting very hard to get patents in those areas. And so I think the importance of the call is to understand the complexity and the specific challenges that are applicable to artificial intelligence, and how that might be used in practice to overcome some of these challenges now at the Patent Office, and also at a policy level, why it's important to provide this type of protection for these technologies.
Okay. And Sam, what is it that you want people to have in mind as we embark upon the substance of this conversation?
Sam, you might be on mute.
Yeah, I can see him here in the room. Okay.
Well, piggybacking off of what Kate just said, I think a lot of the time when there's major shifts in the law, the Patent Office has a tendency to have knee-jerk reactions, and we're seeing that right now with respect to AI specifically, even though Alice didn't necessarily do that. But I think there's hope here, and there's a lot of I think a positive message that can be made. I mean, AI is a very important field. It's growing. Patent filings are showing that as well, and I do think that hopefully we can describe ways that can help people navigate the patent office and get their applications through.
Okay. Now we have our first question, and it's probably a good question to ask at this point in time before we get too deeply involved in this topic. It's what criteria distinguish an application as an AI application? Kate or Sam, do either one of you want to try and tackle that so we can maybe just get some definitions out of the way so we know what we're talking about here?
Well, there's two sides to that question. One is, how does the patent office classify an application as an artificial intelligence application? And one is, what does artificial intelligence mean? And in terms of the first, that is important to the data that we're going to be looking at. The patent office, as soon as they get an application, will assign it a technological class. And how they do that is a bit complicated. I think it's a mix of, ironically enough, AI and then human review. And so the class that we're looking at in our data is class 706, and it's specifically artificial intelligence. That's not to say that every application that has to do with artificial intelligence is necessarily in that class, because it also will matter how it's applied. So for example, if you're using artificial intelligence to facilitate self-driving car, and then that application may get assigned a class that has to do more with an automotive than with artificial intelligence. So that's the first question. The second one, in terms of what is artificial intelligence, that's also a complicated question. It's software that's making some sort of decision that we associate with a human thinking process. So oftentimes people think of machine learning as being the prominent type of artificial intelligence. There are also knowledge-based systems that are included within the category, particularly in the patent office. They have two big subsets of artificial intelligence, the machine learning and then the artificial intelligence, then also the applications. And you can think of some of the complications that have to do with these in terms of separating it from just normal software, normal rules, in terms like how do you react to a circumstance when your data or your rules are uncertain, right? And that you're not necessarily sure what input data you're getting, or when you know that your rules need to evolve over time. So those are some of the complexities that require sophisticated analyses that's traditionally associated with human decision-making, human intelligence.
Okay. Now, Sam, can you tell us a little bit about what Class 706 is, or how one may wind up in 706, or maybe a little bit more about what the office does to funnel cases in certain directions, or do you have any information on that front that you could provide?
Well, so as Kate says, it's a combination. The Patent Office uses a combination of sort of AI algorithms and personnel oversight to determine where cases go. So it could be anything from keywords in your spec to what your figures look like. That kind of analysis will go through, and they'll try and figure out where it belongs. And ultimately, you might even find that cases will end up with one examiner. The examiner takes a look at it, decides that he doesn't want it, or decides that it doesn't belong in his particular art unit or classification, and things can kind of pass around the office. Although that, I will say as a caveat, only happens before prosecution begins. But yeah, so it's sort of a combination of AI and sort of personnel oversight.
So is 706 then more like what we would call sort of like a pure AI? I mean, it's sort of the way that, we have 705 would be maybe pure business methods. Is that a fair way to look at this? If there's any, I mean, I don't even know what pure AI would be.
No, It will include applications. I think what the Patent Office tries to do is to look at what is emphasized, what the innovative concept is, and if 90% of the claim is focused on the application part of it, and the new aspects have to do more with the integration of the results, I think ideally that will be assigned a different class. But if the new result has to do more with artificial intelligence and the use of it and a creative framework for it, I think ideally that is what will put the application in 706. But it does include applications.
I see. So that makes this even more important and more depressing in some ways. But rather than me sit here and talk about that, let's get to the data, I think, first, so we can then circle back to why that might be a little bit more alarming then. And in the first, these are and any time we talk about software here, I always like to have just, the basic preliminary few slides so that everybody's on the same page. This is the Alice Mayo framework. You probably all are familiar with it. We're not going to spend a lot of time here. This is, the first step is the statute. You ask about the categories, and then you go to the step 2A is it directed to, in this case, an abstract idea. And then step 2B is, does it add significantly more? And then we have here from the MPEP, I got a couple slides here that say it may be significantly more if it's these things, including improvements to technical fields or improvements to the computer itself, for example. And then it may not be significantly more if you're simply just applying it or it's well understood, routine, or conventional. And we'll circle back to this towards the end when we begin to talk about Burke Himer and debate whether Burke Himer has any real relevance to AI. But this is where really the meat of the presentation begins, and I'm going to turn it over to you, Kate, first, because this is the data, the first one of the slides that you sent to me, and I looked at this and a few others, and my eyes really just opened. So can you explain to us what we're looking at here, please?
Certainly. Well, within this slide, Gene, you've seen this data a lot. We've been looking at this since Alice came out, and you at IP Watchdog, you've been looking at it long before that. So these are the business method art units. They're in 3600. Alice has to do with business method cases. They were looking at cases assigned to the business methods. This was a Supreme Court case. And after the Supreme Court said you cannot patent this type of technology, not because it's not new or because it's obvious, but because you just can't patent that type of thing. It's ineligible subject matter. In 2014, then we all turned to the business methods and said, how is examination of these types of patent applications going to change? And we saw a very dramatic result. So the allowances, the probability that any particular communication coming out of the patent office was an allowance, that dropped very substantially, very quickly. And the chances that the patent office was going to start rejecting an application based on the same grounds, saying you can't patent that type of technology, those skyrocketed. So it became very hard to get business method patents. Now, I will say all of this data in this slide and the next two, this is based off of Patent Advisor data because they have a very comprehensive database where they're looking at all the output from the patent office and they're tagging it to identify where is it coming from and what types of rejections and what are the decisions. So that was a really nice data source for it. And so this was in the business methods area of the patent office. And then maybe we can jump to the next one, Gene.
Sure.
But what was interesting is that it was very unique. And so while there was this dramatic trend to some types of software applications, these business method applications, it was largely contained within those art units. So even though other portions of the patent office had to do with other software technologies, they weren't affected. Their allowance rate remained high, and they were not issuing any more patent eligibility rejections than they were before. That's generally quite true. There are a few exceptions, but that's generally quite true. So in this graph, we're looking, the blue line shows the artificial intelligence areas of the patent office, and this pertains to the 706 class that we were talking about before. So you see the vertical line, allowances are high in the left graph. The vertical line, very few, or at least stable, 101 rejections. But, okay, we can switch to the next slide. What you probably already caught is that even though there was no shift after that first vertical line representing Alice, there is a trend, right? So we are seeing now a fall off in the allowances and an increase in the eligibility. And what Sam was the first one to pick this up when I showed him the data. This coincided almost perfectly with the decision of Electric Power Group. So what makes sense then, as soon as Sam he identified the date and he said, well, that's as a result that he just knew the date of the case. And then I went back and I looked, and sure enough, that Electric Power Group has to do with patents that were issued in the 2120s art unit, which is also where the artificial intelligence class is generally assigned.
Okay, and we just got a question asking us about the art units. So what art unit is that again?
So the business methods is 36. It's the 3620s, 3680s, 3690s. The artificial intelligence is predominantly in 2122. And then I think they're also represented in 2124 and 2129. But I'm not 100% certain on what the art unit mapping of that is.
Okay. All right. So now, Sam, when you saw this and you instinctively knew that this was related to Electrical Power Group, how did you know? I mean, I don't know how to ask it other than that. I mean, to you, I guess it was obvious, but it was not as obvious to me.
So I was an examiner in 2192. That was my background before I joined Kilpatrick, and so I was familiar with the TC 2100. And at Kilpatrick so far, I've done a lot of business method work, and one of the most commonly cited cases now is Electric Power Group. Anything that has to do with software, you start to see this pop up more and more, mainly because it's I personally think a little bit too broad of a decision, but still that essentially says that data collection, analysis, and producing result or displaying result is no longer eligible. And from seeing that enough times in business methods, when I started to consider now 2100 and just software-based applications, and I realized that is likely the cause of these AI applications now being overly rejected, or the allowance rates going down, because they're primarily software oriented. They don't generally include, at least the core ones that I've seen, don't always get as far as applications. They tend to start off with training machine learning models or how the technical complexities of the models themselves, and that's the snare that tends to get you at the patent office.
Mm-hmm. Okay, well, let's go to the next slide because we got to talk about this a little bit more in detail. And we got a couple more slides here. So the first is to present the questions here. What does this all mean for artificial intelligence? And I guess the very first reality is it just means that it's going to be harder to get, and these things are going to get more heavily scrutinized, which then does present two questions. Is this shift acceptable? And then is the examination shift really appropriate in view of electrical power grid? And I want to get to the next slide, which begins to talk to us about what electrical power grid actually says and holds. And I want to get you guys to talk about this a little bit. I mean, we have some people asking, what does it hold? And is this really a correct application? And Sam, I think I heard you say that you think that the examiners are overusing this case, and let's have a discussion about this. I mean, what does this case really mean? What should it stand for? And how do attorneys address this? I don't know which one of you might want to take the first swing at this, but this is really the substance of what we need to talk about, I think, right?
I'll let Sam start off. I want to talk about the quote on the next slide, so I'll jump in there.
Okay. All right. Go ahead.
Electric Power Group covered 3 patents. 2 of them were originally assigned and patented by a TC 2100, so art unit. And that actually, I think it paves the way for the reason why it's being applied so heavily in 2100 now. It covered methods that for, I think, real-time analysis of power grids. I think a power company or something like that would be able to analyze incoming data streams and produce some sort of display in real time. The court, when they analyzed the case, even though the claim, I think, was well over a page long, it was dense, boiled it down to really a very simple concept: collecting data and analyzing it and displaying the results of that analysis. And that became our abstract idea that the Patent Office now applies to all these software cases. I do think it's overly broad, what the Federal Circuit did here, primarily because it was the trap that Alice, the court in Alice, tried to avoid, which was, in some sense, everything can be boiled down to an abstract idea. And I sort of think that's what the Fed Circuit did here. Collecting, analyzing, and displaying data is essentially what computers do. It's what any sort of instructions that are executed on a computer do. So you even have some of the judges, I think Judge Mayer in a later case, I think I have it written down here, going so far as even saying that that software is likely not patentable anymore. So, you take all that, and then the Patent Office is going to use that to apply it to now these TC 2100, these software-based cases. And that's why we're seeing, I think, a lot of rejections now coming out of 2100.
Yeah. And I think that case that you're talking about with Judge Mayer, I mean, and I wrote an article a couple years ago now, and I suggested that it was time for him to step down because he has a habit of citing himself in dissent as if was the law of the circuit, and it's not correct. And I think I know the case, and I think it's in that article where he said software is not patentable anymore, and he cites to himself dissenting. But Kate, is this the next slide that you wanted, or do I have them out of order?
Well, we can talk about them in combination, right? So Sam talked about the holding of electric power group that is making practitioners' lives very hard because examiners now say, well, electric power group said that collecting data, analyzing data, and displaying results is abstract and that these claims are now patent ineligible. And if you step back, that seems to cover a lot, if not all, software innovations, right? So a point that Sam and I want to make here is that you have an opportunity to distinguish this case rather well in artificial intelligence. And it's nuanced, but it's very important. And so if you start looking at how does we'll look at the machine learning case in this particular depiction. So you're collecting data, right? And that's, you might be collecting training data, you might be collecting the live data, and yes, that's a parallel to collecting data in electric power group. Then you're training your model. Now, is that the same as analyzing data? Perhaps, right? Because you have some algorithms that are used to train the model. But I would say that's a bit questionable in terms of whether that's a strong parallel. But then the strong point here is that you're going to process some live data, it could be live or stored for some period of time, but data of interest. You're going to process that using the trained machine learning model. And I would contend that that's the part here that's not analogous. And the reason is because you are developing, when you're training the model, when you're setting up the model, the code that somebody is configuring, yes, you're putting in rules, you're putting in algorithms, but you're setting up like a framework, a system. And the actual algorithms that are going to be used to process the live data or the input data, you don't really know how it's going to work. And that's why it's very cool, the use cases of AI, because you're setting up a very complicated system where you have to make sure that you're doing a good job choosing your training data set and that you're providing a good learning framework so that it learns correctly, so that it's doing it's making the types of decisions that you want it to do. but you don't know what those decisions are going to be. And oftentimes they're changing all of the time. It's often hard to even interpret it and to understand why decisions were made, right? So I would say that that kind of processing using a machine learning model, and we can separately talk about knowledge-based systems, although that gets a little bit in the weeds and is case specific, that is not analogous to analyzing data in electric power grids.
Mm-hmm. Okay, so let's go to the next slide and talk about this and get this all out on the field, because we have a question here about what should you do when an examiner is misapplying electric power grid, and I think we're going to be talking about this here over the next couple slides as we kind of dissect what is actually said here. And Kate, is this? I think this is the slide with the quote that you had that you wanted to specifically address, correct?
Sure. So when Electric Power Group is talking about why analyzing data is part of the abstract idea, this is a quote from the case. Right? We have treated analyzing information by steps. Let me downsize. I can't read the whole thing, but the important part is if you're analyzing it through your mind or by mathematical algorithms without more, it's essentially a mental process. And so the two important parts of this is or by mathematical algorithms, because yes, mathematical algorithms underlie AI. They underlie machine learning algorithms and software. Now, going back to my discussion from the previous slide, is it important that those mathematical algorithms be predefined? Because in machine learning cases, yes, the structure might be predefined, but oftentimes the weights, support vectors, right? All of these additional features are learned. And so the actual algorithms that are used are not. And then also important is essentially mental processes. I would contend that AI goes well beyond that. And that's why you're setting it up, because you can't set forth all of the rules. You can't go through this in a person's head. It's too complex in many cases. The machine learning model, you can't set forth the rules because it's changing or because you won't be able to do as good of a job. For knowledge-based systems, the data might be uncertain. The rules might be uncertain, have some uncertainty on it. The hierarchy might be hard to define. The order, you might be confusing where do you start, right? So these are the types of things that make it hard to say that it would be the same as mental processes, and it provides an opportunity to distinguish AI technology from the analyzing data of Electric Power Group.
Yeah, and this is one of the things that I had specifically pointed out when several years ago now, when it was in vogue for the Federal Circuit to be saying, oh, that you could do this stuff with pencil and paper. No, you actually can't. For the variety of things that we're talking about here, it is impossible for a human to actually do these in any lifetime, or in any 10 lifetimes, or in any 100 lifetimes. You just couldn't do it. So what we have, I think, is an unfortunate reality where we call software the same thing that you download from the Apple App Store that will, track your calorie intake, or, a calculator that is a very simple piece of coding. And it is also software when you're talking about an AI system that is going to be put into an Android that is going to be like Data from Star Trek. And those pieces of software are of wholly different magnitudes. And the calculations that can be done by AI just cannot be done in a relevant time frame. And I think that is something that has to be pointed out, and it has to be articulated. And we're going to get to talk about this a little bit, but you have to, I think, also look at the clues, right, from some of these other cases, and EnFish and others, where while they may not be particularly relevant to this technology, what they're talking about is defining the innovation in a way that explains what is the innovation. And if your innovation is not a mental process, essentially a mental process, you need to make sure in the application that it's defined in a way that explains it is not a mental process. This is something much more special. Would you guys agree with that? Sam, I mean, is that what you need to do, you think?
Yeah, I think that's exactly right. Back in the Bilski days, you saw a lot of software applications that define things in terms of results that were happening as a result of processing on a generic processor or computing system, and those kinds of things, passed muster at the time, and that was enough. And now Alice has come out, and Electric Power Group, and they're really showing that you really need to point out that technical point of novelty, and that it's not, just a simple result-oriented application.
Yeah. Now we have an attorney here who said that, he's making similar arguments here, and the examiners are basically ignoring them and giving very broad meanings. I mean, at that point, what do you do? I suppose the only thing you can do is appeal, I suppose. I mean, maybe not. Let's hold that question for right now, because I want to come back to that towards the end. We got to push through, because there may actually be some hope at the end of this tunnel. So let's hold on to that for right now. But some more on electric power grid. Do we need to? I think we've talked about this. Is there anything new on this slide here, guys, that we need to?
No, I think that's fine.
Okay. And then on this slide gets us into the Burke Himer stuff, which, I don't want to beat with a dead horse, because you probably are all familiar with Burke Himer, but this is the case where it said that these things are factual questions, whether or not it's well-known conventional routine. And then we have the Burke Himer guidance, and then the Burke Himer memo that sets up this 4-part inquiry that the examiners need to go down and go through. And I put this here simply because it just seems to me that when you look at all of this, at the end of the day, where the action here for AI is going to be in that step 2B, where it's going to be, they're going to nail you with it being abstract, which is, I find hard to believe, but it is, I suppose. It is what it is. And the hunt for the inventive concept, it seems as if there is some real question in America whether or not artificial intelligence is inventive. And that is also equally disturbing to me. But so we're going to come back to this here in a minute, I think. But I want to get this all out on the table before we start answering questions and start talking about advice and getting into the free flow here. Earlier this week, Director Iancu was giving a speech at Georgetown. And in this speech, he made some very strong pronouncements about what we're going to start to see coming down the pike from the USPTO. And he said that essentially he wants the Patent Office to very strictly follow what the Supreme Court has laid out. And based on what he can see and the office has done on their review, abstract ideas can be synthesized into 3 categories: mathematical concepts, certain methods of organizing human activities, including fundamental economic practices and legal interactions, and then mental processes. And those are abstract ideas. So I think we're going to see the Patent Office here in very short order, because when he's been given speeches like this, in very short order, we've gotten some guidance from the Patent Office. They're going to define abstract ideas as being, I think, one of those 3 things. And then if they're not one of those 3 things, then it's going to be, the examiners are going to be directed to find that it is patent eligible. And they are going to very strictly follow what the Supreme Court has laid out. And I think that this is going to be pro patent applicant, and we'll see where this winds up going. But essentially in his speech, he said that he doesn't think that the judicial exceptions should be allowed to swallow the statute whole. So I think in very short order, we're going to get some good guidance from him in the office on 101. And now I think let's go back and think about what do we do here now when people are not maybe following what electric power says they should be doing, and are not necessarily following the Burke Himer memo. They're giving broad interpretations. I mean, what advice do you give your clients? Let's start, Sam, with you, because I know you work specifically in these art units. What strategies do you think should be employed?
Well, I think first off, the way patent examiners are trained to apply at the subject matter eligibility, they essentially have to find the abstract idea, right? And then now, thanks to Burke Himer, anything on extra or anything in addition to that abstract idea, they have to figure out whether that extra portion is routine, convention, or well known in the art. So the struggle we have here, and what we're seeing at the patent office, is that examiners essentially lump the entire claim. They just really wanted to group all of those limitations into that electric power group, collecting, analyzing, and displaying a result. And that way, they actually have very little Burke Himer analysis to do. Maybe they only have some generic computer parts, and that's really relatively straightforward for them to dispose of. So I think in practice, what needs to be done, you need to really distinguish that how that model is processing the data and how that is not just simply analyzing data. You know, as Kate said before, the technical complexity of how the AI or the machine learning model, whatever, is processing data is there's no human analog. There's no human equivalent to that. And I think that's the first step is being able to get the examiner to see that at least a portion of this claim, the inventive concept, if you will, is not part of that electric power group analysis. And then from there, you can move on to a more of a Burke Himer argument and try and distinguish that these are not simply well-known, routine, or conventionally known techniques in the art.
Yeah, Kate, any thoughts, any advice before we start? We got a lot of questions, but I want to give you some.
I mean, certainly there's a difference. You asked about in prosecution. That's the way I'm understanding it. Once you're faced with this rejection, once you're faced with the stubborn examiner, how do you deal with it? Of course, Gene, we could give a whole nother talk about how to draft an application, right? We're not going to go into that. We should be emphasizing this from the beginning. But once you're there, so you can make the argument to the examiner, there's a lot of other prosecution techniques. That's not the decision maker that you're necessarily stuck with. You can appeal the case. You can try to bring in a supervisor. If they're not a primary, you can bring in the other examiner. You can figure out who you want to be talking to. If they're not a primary, there's going to be two examiners in the room. Definitely interviewing, potentially bringing in an inventor, maybe filing a declaration, right? There's a lot of prosecution tools. I will say, going back to patent advisor, data is important, right? You can look all of these players up. You can see how successful have these arguments been with our type of technology if going up on appeal or within the art unit generally, right? So you should be looking at the data and then choosing which one of, a dozen different strategies you want to use. Pre-appeal brief, AFCP, right? Like all of these are options at your disposal.
Yeah, and somebody was just telling me the other day that they filed an appeal brief, and as soon as they filed the appeal brief, they got an allowance. And he asked me, how common is that? And I said, well, if you go to Patent Advisor, you can look this up and you'll be surprised maybe to see that there are a lot of these no patent for you ever examiners that if you actually file an appeal brief, they suddenly become, well, maybe I can give you a patent examiner. And
Gene, I think on IP Watchdog, we published a study before that showed there's a correlation. So the higher the allowance rate of the art unit, the more likely you are to have that happen, which goes in line with the fact that the supervisor has to sign off on it, right? So it makes sense there.
Yeah. So it's not like going to be like in these art units where the allowance rate is like 6%. That's not a strategy that is going to work, because the way you get an art unit that has an allowance rate that's 6% is the board orders them, reverses all the rejections, and then they run out of rejections that they can make, and that's how they get issued. But in a art unit that's maybe low, you're dealing with an examiner that has a lower allowance rate in an art unit that is relatively reasonable. there are strategies you could employ. And but if you don't know the data, you don't necessarily know that. And there's ways that you can do this that save money for the clients too, but it's all data driven. And I don't want to turn this into a commercial, but the data is important, and that's how we even know that electric power grid is as important as it is, because the data shows us that. But I want to get back to what Director Iancu said earlier this week, and I wonder, because he said this mental processes part that looks like they're going to get ready to define abstract ideas. He said mental processes, which are concepts performed in the human mind. So it seems to me like they're going to try, or he's going to try and dissect artificial intelligence from the pure business method patent that may be at issue in Bilski. And that would make some sense given the questions that he was being asked over the summer by senators who, particularly Kamala Harris, who is in a district where there's an awful lot, or in a state where there's an awful lot of companies spending money researching artificial intelligence. So one of the things you might think about is if you're in one of these art units and you're having trouble right now, and there's ways to keep these cases alive, now is not the time, I don't think, to let these cases go abandoned or do anything drastic, because there may be some help on the way in relatively short order that could change the way that you're going to want to argue these things. So I would try and keep these things going, because I think things are going to change again, and we'll see what that winds up meaning. Now, we got some questions here that I think I would like to try and get to. Let me just pick one. Let's see. I'm an engineer, so this may be a silly question, but does the shift argument to machine learning training models, because it's too complex for humans, address 101 issues? Could it also backfire to cause an inventorship issue, or not having possession of the invention or algorithm issue? And we also have a question very similar to that, asking about, well, maybe not the same question, but also an inventorship question about, well, what about AI actually being the inventor? I mean, there are some inventorship questions that the Patent Office hasn't even begun to address in this topic.
Well, I think it depends on what you're trying to protect. And so if you're trying to protect the learned model in a particular way that you are then processing data, and then that would be problematic, right? So it's been trained over a month with using a complex data set, and that creates issues that I don't think are resolved at this point in time in terms of inventorship. If you're trying to protect the framework and say, here's the framework that we've set up, and it has these advantages of how it can be used, I think there are particular ways to say each one of these steps I've created. It wasn't the machine, it was what I'm doing. And the overall framework is not what's analyzing the data, the actual data that's going to be the result, but it sets up, it's kind of like a system level, right? And I think that should not be questioned in terms of inventorship.
Yeah. Now I have another question here, and I agree with this. He says the notion that a mathematical algorithm is an abstract idea is maddening. A well-defined algorithm does things just like mechanical instruments do, and cannot be done by an unassisted human brain. Why should that not be patentable? And I agree with that, but I guess maybe the not a better question, because that's a great question, but maybe the better question for our purposes here is, how do you articulate, or are there ways to articulate a mathematical algorithm? Are there ways that you can make arguments with a examiner to accentuate the mathematical algorithm to make it seem not abstract, to get to get knocked down on 2A so you don't get to 2B? Sam, you're the former examiner. How do examiners think? What can we do? Because he's right. Mathematical algorithms, if you're written properly and explained they do the same thing as a tool could do.
Yeah, I mean, I think judges and the Supreme Court in general has also struggled with software in general. I just don't think they necessarily understand what's involved. And I think they look at it abstractly in terms of, well, we just a discrete set of instructions and a person can follow instructions and therefore it's abstract. And I agree with you, Gene. I don't think that this is by any means should be considered ineligible subject matter. I think you really need to put it into terms about what the algorithm is doing, how it's transforming the data. I would generally avoid talking about results, just mere results, because examiners will probably just ignore that anyway. And I would not refer to it as a mathematical algorithm, but that's just me.
Okay. Yeah. I mean, I think if you refer to it as a mathematical algorithm, then you're kind of probably in trouble, I suppose. Okay. So, another question here. Does this, everything that we're talking, this is from a bit ago. Does this mean that you need to claim specific elements, example calculations, that are impossible to be performed by a human in order to get around the electric power case?
You'll
I think that depends
have
on
a
your
hard
use
time.
case.
Oh, okay. So we both want to talk about it. Sam, you go first, and then Kate, I want to get your input on it as well.
As an examiner, having math in a claim confuses examiners. The search algorithms that or the programs that examiners use doesn't really allow them to enter in math. So generally, if you have a complex mathematical formula and you put it in the claim, you're going to have a hard time. The examiner might have a hard time searching it. You might either end up with a rejection just because he can't search it, or a rubber stamped allowance. You sort of end up, I would say, maybe about 50-50 on either end of that spectrum. But I don't think generally putting math in the claim is a good way to go. I think it just makes the claim confusing to people to read, and so then the scope becomes a little confusing. And if the claim ends up looking like a math claim, math is not a subject matter eligible. So I think you really need to put it into different terms. Like I said, I think the better way to go is probably to describe how the types of analysis transform the data in a way that can't be done by a person.
Yeah. Kate, your thoughts?
And I'll piggyback off that. Yeah, I like to think of AI in a lot of software claims in terms of the transformations. And for me, just based on my background, I do visualize it, because that's how I got through coding when I was back in grad school. And so I'm thinking about, what does the neural net look like? How is your neural net different than anything else? What does the data stream look like? How is the data transformed through different stages? And so while you don't need a specific algorithm, going into those different steps, and I understand that it's a little iffy in terms of where 101 stands now, but talking at a higher level in terms of the transformations and the processing that's occurring, that's generally the level that I like to concentrate.
So we have another claim question. Might as well try and tackle this since we're talking about claims. Are there one or two things that you look for or could put into a claim that will improve the chances of avoiding a 101 rejection? Now, I mean, I know that, and everybody always gets upset when I say this, but, if there's tangible stuff in your claim, that helps, right? I mean, it just does. And people say, oh, well, that's not what the Supreme Court said. That's wrong. That's not what the law is. Well, it's the reality. I mean, it's not it's not a safe harbor. It's not like machine or transformation is the law, but if there are things there that people can touch, it makes it look more like a machine. Like Sam was just saying, if your claim looks like it's a math problem, then you're not going to get the claim. I mean, if your claim looks like something that is more like a machine or device, then you're in a different place. I mean, that's my advice. Thoughts, Kate?
I agree with that. And it's more than what it used to be, right? You used to be able to slap on processor and a memory, and then that would be sufficient. But trying to really integrate it into any hardware to the extent that you can, I mean, it's great. Like, what if you have a robot and you're integrating machine learning into that? Or what if you have a vehicle and you're integrating machine learning into that? And perhaps the novel aspect is the machine learning or the knowledge-based system, but the device is then doing something differently than it was doing before. Those are going to be relatively easy to get through. So to the extent that you can actually integrate it into software, talk about the specific sensors the data is coming from, should that be different if the new part of it is the processing? It's a topic for another day, but it helps practically.
Yeah. So we have a question here along these lines. What if you have two machines interacting through AI? Then it's impossible to say that a human could do it. And, that's, I think, sort of what I'm talking about here. If you have a couple, if you have I like to think of these, and not to say that this is the only claim you're going to want to have in your patent application, but this is, I think, low-hanging fruit, right? If you can envision what your client has invented as a system, a human can't be a system. You can't have multiple machines communicating over vast distances. Think about like a satellite communication system. A human can't do that, right? It's not in your mind. It's not an essential mental process. There's a lot of stuff going on there. The fact that AI is being used to implement pieces or part of it or run the entire thing is wonderful and great. Now, that isn't going to save everybody's application, because the AI is a whole lot of different things, and it can be much more modular. But those are the types of things I think you want to look for, right? Right, Kate? Right, Sam?
Yeah, so I would say, like, concentrating on the complexity and what can't be done by a human is a very strong approach. But to add a slightly different flavor to that, there was an application I was prosecuting a while back, and it had to do with entropy and information theory. And we hit the same topic, even though it predated this case. And I told the examiner, you can't do this in this particular way that we're calculating entropy. Humans couldn't do it, right? And I started taking them through log tables, right? And I was going through the math of what it's like to calculate entropy. And you could calculate a few entropy values here and there, but in the context of which the entire system was working, I was showing him why mathematically it was not practical for a human to do this at all, right? And so those types of arguments definitely should be made.
Yeah, and did that work in that particular case?
Yeah.
Yeah. See, I think one of the things, we've done this for many years, right? For probably my entire practice and before, where you would have an examiner make an obviousness rejection. And you say, well, it'd be obvious to put A, B, and C together, and you would do exactly what your invention does. Well, if you would look at that and say, well, if we actually put A, B, and C together, that's actually not going to work. So then what you might do is you might put A, B, and C together and show that it fails, and it didn't work. I think you have to do some of that stuff right now with this software stuff, because these examiners are just waving magic wands and saying, oh, yeah, you could do this. A human could do this. Anybody could do this. It's just in your mind, and they're picking up on this idiotic statement from either overtly or, subconsciously from Justice Kennedy and Alice. It's, oh, yeah, you could code this up over a second-year engineering student could code this up over a weekend at a Starbucks, and that's no, that's actually not correct. You couldn't do that. So I think you have to demonstrate that it can't be done. And that maybe seems idiotic, but there's a certain amount of it that I think is examiners protecting themselves. Sam, could you talk to that for a second? I mean, and I don't know whether when you were at the office it was that way, but I think to some extent, some of the supervisors maybe, let's just say, don't share the view that as much ought to be patentable. And if you're an examiner and you do think that maybe more ought to be patentable, you really need to cross your T's and dot your I's, don't you?
Oh, absolutely. I think it works on both ends. I mean, I have some colleagues of mine that I started the patent office with that are still there that don't allow cases the way that the rest of their art unit does, and they get a lot of pressure from the higher ups to try and allow more cases, believe it or not. But so examiners can get what they call errors. Usually it's for making a rejection that they shouldn't have, or rejecting a case that making a rejection that they shouldn't have, or missing a rejection, so failing to do a one-on-one rejection, for instance. They're not usually caught very often, but they can lead to some undesirable repercussions, like not being able to work from home anymore, or losing bonuses and things like that. So examiners do try and protect themselves as best they can, and sometimes that means making the rejection just to get an argument on record, even if it's unfair or doesn't really apply in this particular circumstance. And then you do have certain supervisors, and without naming names, but there's one in 2122, for instance, in this AI art unit, who I've been told from some examiners just refuses to let certain cases through. And so it doesn't really matter what the examiner decides or what the examiner thinks is right or wrong. Ultimately, because the SPE is going to be signing the case, or the primary is going to be signing the case, it ends up being the primary as the decision maker, even though the junior examiner is the one who's giving you the rejection or talking you through it.
Yeah. Kate, do you have any thoughts there on that?
I'm sorry, I was listening to Sam too much. What was the question again?
Oh, no, that's fine. Because I mean, the question was just talking about, making sure, because sometimes I think, and I know this for sure because I was teaching in a patent bar review course this summer, and it was a couple former examiners in the class, and they're studying to take the exam, and now they're tech specs at firms in the Northern Virginia area. And I was just talking to them, and I asked them, did you work for the patent denial authority or the patent granting agency? And they said, oh, we worked for the patent denial authority. And I'm like, oh my God, you're killing me. And they're like, no, it wasn't us. It was our supervisors. And so we talked about that a little bit more. And it was one of them said the supervisor had a standing policy that you could, no matter how narrow the claim was, no matter how good it was, under no circumstances could you ever issue on a first action. Now, and I know you don't want a first action allowance. I mean, sometimes people do, but usually you don't. And what she went on to say something, and it just triggered a memory in my mind when Sam was talking, because it was the policy was make the rejection, come up with a rejection, and force the applicant to make the argument on the record. So some of these things are, and not in the areas necessarily where the examiners are refusing to play ball, but some of these rejections are made because the examiners want you to make the record so that they can say yes, or so that they can be confident in their no. Thoughts on that, Kate?
I think it goes back to a point from before, and you have to know who the possible decision makers are, who in reality the decision maker is, and who do you want the decision maker to be. So in the cases that you're talking about here, you might think it's the examiner. In fact, it's not. And so by identifying who you can talk to the examiner, figure out what the issue is, they'll tell you. You just need to interview with them, right? And try to get the right players in front of you. Change that if necessary, and then also introduce the human element. If you're talking to the examiner, if you're able to put the inventor or the client in front of the examiner, that will help, and it will get them away from rejecting everything because there's a face to it. And you can explain why, like I said, to this examiner with the entropy case, let's do it. Let's go through the math, right? I have all the time in the world, but that conveyed the point. So I think that identifying the correct decision maker and really getting in front of them and presenting your case and explaining why this is just not possible for a human to do, why it's too complex, emphasizing all of the complexities, that's the best approach.
Yeah. Now, the other thing here, and I know we're at the exactly the hour, and I want to give you both a chance to wrap up and rapid fire succession if we can here. But we have somebody that says, what do you do if you just have essentially a recalcitrant examiner? Now, I tell people this all the time, and nobody ever does it. But I know for sure that if you have examiners that are just not doing what they're told to do, and particularly after this next round of guidance comes out, which seems like it's going to be very patent applicant friendly, if they continue to not follow this and do what they're supposed to be doing, you are going to have to contact the commissioner. And the commissioner tells me, and I know the commissioner, and I've known him since before he was the commissioner, and he tells me every time I talk to him, we have the same conversation, because I bring it up, and he says, tell attorneys that if they see something out of the ordinary, to give me a call. He said, I can't fix things that I don't know about. And he wants to know, and it's not that he can reach in and fix everything, but the office is trying to make things better. And I don't think we can assume that what the people know on the 10th floor is going on in the trenches. So if you see something out of the ordinary, I think you have to call the commissioner. And if you feel like you can't do that without ruffling feathers, you call the commissioner and tell him, I listened to Gene Quinn, and Gene Quinn tells me that you told him to have attorneys call you. And he's told me to tell people that. He wants to know. Drew is a good guy. He really wants to make things better. And I think the patent system is in good hands with him running it as the COO. Now, I'll give you guys the final word. So, Sam, let's start with you, and Kate, we'll go to you. Sam, in 60 seconds or less.
Well, I guess a high-level summary. I think there's a lot of there's a certain amount of negativity, at least in terms of the numbers. We're obviously seeing a large, an increasing number of rejections coming out of artificial intelligence art units, and the allowance rates are going down. But I think there's room to be positive here. I don't think that Electric Power Group, although ubiquitously applied, is a good fit for artificial intelligence. And I think that carefully crafting your arguments or getting in front of the examiner in an interview, I do think there's room to move ahead here and get past Electric Power Group. Yeah.
Okay. And Kate, your final thought.
Yeah, I'd second that. Artificial intelligence is typically extremely complex. Getting into the complexity and making sure you understand it before you draft a case, and then explaining that in an interview and throughout prosecution, you should be able to distinguish it in many cases from Electric Power Group. And like Gene said, with the new director, I think we have some promise in terms of getting this allowance back in the realm that makes us as practitioners a bit more comfortable.
Okay. Well, thank you, everybody. And thank you to LexisNexis IP for sponsoring this webinar. They've been a good, very long time sponsor of ours. And they also provided the data that we used today through Patent Advisor in order to identify these trends. And so if you have any interest in taking a test drive of Patent Advisor, I know that they will be happy to show you what it can do. And I think once you take a look at it, I think you're going to have your eyes open as to what you may be able to do with it in your daily practice. It's a great one. It's a great tool. So thank you, everybody. Really appreciate it. Thank you, Kate. Thank you, Sam. And we'll hopefully see you again at another webinar here in the future. We have another one coming up with Lexis on December 13th. So stay tuned, and we'll see you again. Take care.